Hello everyone and welcome back to Law Statistics. Today's presentation is based on most important topics for legal reasoning and their lucid explanations. Now, blasphemy laws in India. Section 295A of the Indian Penal Code 1860 criminalizes insult to any religion. It allows up to 3 years imprisonment and fines for whosoever with the deliberate and malicious intention of outraging the religious feelings of any class of citizens of India by words either spoken or written or by signs or by visible representations or otherwise insult or attempt to insult the religion or the religious beliefs of a caste. But the law should not be read in this strict sense. Now, instances of blasphemy. Burning a religious document such as the Bible or the Quran is considered as blasphemy. Vandalizing a church is a form of blasphemy. Worshipping Shaitan is a blasphemous. Defense to blasphemy law. In Mahendra Singh Dhoni versus Yering Untla Sham Sundar, a case for allegedly harming the religious conclusions of individuals when a picture of Mahendra Singh Dhoni being depicted as Lord Vishnu was distributed in a magazine with an inscription Divine Force of Big Deals, the court said that Section 295A IPC does not stipulate everything to be punished and each demonstration would equivalent to affront and endeavor to affront the religious or the religious convictions of a class of subjects. Now, copyright protection of cultural traditions. Copyright protection of cultural traditions. The traditional cultural expressions, also known as the expression of the folklore, has its root in the culture of the indigenous local communities. Traditional knowledge is employed to mean knowledge, innovation, practice, and indigenous and local community to such an extent. Copyright protection of cultural traditions. Apart from increasing competition in the international market, there are various other debate points in the issue which makes it a major IP point topic for the ongoing worldwide debates and the center of the rising treaties and agreements. The reference of which can be taken from the Berne Convention, which made an attempt to provide the copyright protection for folklore at the international level, or the WPPT and WCT adopted in the year 1996. Copyright is available for contemporary versions, interpretation and adaptations of pre-existing traditional cultural expressions. Article 15.4 of the Berne Conventions provides protection for the unpublished works of unknown authors. Recording of TCEs are protected as sound recordings. Performance of TCEs are protected. Moral rights. Rights to attribution and to prevent are concluded. However, despite these existing forms of protection, there is, I could say, a widespread view that some interventions are needed in order for IP systems to respond more adequately to the aspirations and need of indigenous peoples. Curative petition, review petition, and mercy petition. Prominent case, 2G spectrum case. Government of India filed a review petition in the Supreme Court in March 2012 seeking partial review of the order by court passed in February 2012 which had quashed 122 licenses that was issued during the tenure of A. Raja as a telecom minister. Systema, who was a majority shareholder in MTS India, also filed a review petition in Supreme Court. Review petition. In India, a binding decision of the Supreme Court, High Court can be reviewed in a review petition. A review petition is filed by the parties aggrieved by the decisions of the Supreme Court. The provisions of review is an exception to the principle of stare decisis, as a courts generally do not unsettle a decision without a strong case. Curative petition. The Supreme Court evolved this concept in the case of Rupa Ashok Hurra versus Ashok Hurra. where a question was raised that whether an aggrieved person is entitled to any relief against the judgment of the Supreme Court after dismissal of review petition, where the court said that a curative petition is required to be certified by a senior advocate and then it is to be circulated to the three senior most judges and the judges who delivered the impugned judgment. Therefore, now mercy petition is the last resort when a person has lost all the remedies available to him her under all of the prevailing laws as well as under the constitutional remedy. He may file a mercy petition before the President of India under Article 72 or to the governor of the state under Article 161 of the Constitution. Then the petition of his will be treated on mercy, not on the legality of the case. That's all for today's presentation. Thank you and have a great day ahead.